Paul. Yes. I was reading that domestic violence judges manual. Yes. Determined in accordance with RCW 26.27. Oh. And in accordance with the Parental Kidnapping Prevention Act of 28 U.S. Code 1738, the Parental Kidnapping Prevention Act. Yes. Now, that RCW 26.52.080 further provides that law enforcement officers shall not remove. Yep. You cannot remove a child from his or her current placement unless, there's a writ of habeas corpus to produce a child issued by a superior court of the state of Washington. There's probable cause to believe the child is abused or neglected, and the child would be injured or could not be taken into custody if it were necessary to first obtain a court order pursuant of RCW 1334.05. Now, as a father, the Washington's Foreign Protection Order Full Faith and Credit Act plainly states that the venue, yes, and jurisdiction issues concerning child custody are decided in accordance with the UCCJEA 26.52.080. Look at that, the Washington's Foreign Protection Order Full Faith and Credit Act. You know, I was reading through this, and I thought there was a court order from Guam to dismiss the actual case and expunge my record. But it looks like the states don't really recognize the Washington State Foreign Protection Order Full Faith and Credit Act. Pooch. Now, I was wanting my sons, and you thought, well, we can do whatever the fuck we want. Pooch. This was consistent with the VAWA as originally passed in September of 1994. At that time, the definition of protection order specifically excluded child custody orders. You remember that dissolution of marriage where I didn't get any due process? However, in the 2006 amendments to the VAWA, Congress expanded the definition of covered protection orders, any support, child custody or visitation provisions, orders, remedies, or relief issued as part of a protection order, restraining order, or any stay away injunction pursuant of state, tribal, territorial, local law. Now, this dissolution of marriage that you said, no, he doesn't need to get notice of court hearings. Oh, I think it could be in violation of the Washington State Foreign Protection Order. Now, maybe there's a judge that wants to read that manual again. Pow! Because I was sure that when I sent the emails, yes, and I had documented that there was a judge that had actually violated the Washington State Full Faith and Credit of Foreign Protection Orders. You violated another law. Pow! You get to get sued again. Now, this was consistent with the VAWA as was passed in September 1994. Any support, child custody, or visitation provision, or orders, remedies, or relief issued as a part of a protection order, restraining order, any stay-away injunction pursuant to state, tribal, territorial, local law authorizing the issue of protection orders, restraining orders, or injunction for the protection of victims of domestic violence, dating violence, sexual assault, or stalking, 18 U.S. Code 13925. Therefore, child custody and visitation provisions of tribal courts, the Indian courts, and every reservation protection orders are entitled to the full faith and credit to the same extent as all other provisions of the order. Now, these state and tribal courts that work together, yes, it's known as the Foreign Protection Order Full Faith and Credit. And the Violence Against Women's Act are designed to provide legal mechanisms for the cross-jurisdiction, yes, enforcement of protection orders between tribal and state courts. Now, I know that I emailed a lot of the reservation. Well, you didn't just violate the RCWs to be able to issue a dissolution of marriage or protection orders. You violated the Foreign Protection Order Full Faith and Credit Act. Now I'm going to sue you for that!